Let me hit go live. It just spools up for a few seconds.
And I would just make one more statement to Neil Young to turn on the audio.
And video. We are now live on YouTube. The meeting is yours, Commissioner. Let me know if you need anything.
Good morning. And I am just pulling up my statements. I want to make sure I have both screens going. Good morning and welcome to the Town Hall on revisions to rules governing practice and procedure at the Unemployment Insurance Appeals Commission. I am Julie Petrick, chairperson of the commission. Today is February 11th, 2020, and the time is about 10 o'clock in the morning. This town hall is being conducted today using remote technology. As much as we would like to be with you in person, in order to keep members of the public, the commission and staff safe from the COVID-19 health hazards, we are using remote technology. The commissioners are all appearing on video by virtue of Zoom, and members of the public may attend using telephonic or Zoom technology. The town hall is also live right now, as Ken just mentioned, on our YouTube video channel that can be accessed through the UIAC website in the Commission News section. In attendance today, we have the full commission, and this includes Alejandro Del Pino, Lynn Morrison, Lester Ocharski, Andrea Rossi, William Runco, and Neil Young. We also have some members of the commission appearing. We have 4 administrative law specialists. This is ALSs for short. They are attorneys that conduct case review and provide advice and consult with the commissioners. And they are Mayanne Damares-Gazolka, Nancy Kulkowski, William Ramirez Roberts, Jay Vela. We also have our office manager, Verna Curtis. A year ago, the commission began reviewing the rules with the goal of making changes to improve the process of appeals adjudication to better serve the parties and the public. While we at the commission are intimately familiar with the process from the viewpoint of an administrative agency, we wanted to better understand the process from the viewpoint of the parties that practice regularly before the commission. Accordingly, we invited practitioners and members of the public to submit their suggestions for comments for revisions. We received valuable input and suggestions, and those ideas have been posted to the website for all to review. This town hall today is a continuation of that process. We believe that we can best achieve our objective through engaging in dialogue with members of the public. The proceedings today will go as set forth in the notice. The town hall notice informed the public of the opportunity to make a presentation. We have 2 sets of presenters today. The first by Rachel Cole of the Workers' Rights Clinic at the University of Michigan Law School, and she has 2 students with her today. Her group has 5 minutes to make a presentation, which will be followed by Q&A by the commissioners. She will be followed by Dorian Slaybod of the Farm Workers Legal Services, and the same procedure will apply. I think we have sufficient time today that we can be a little bit liberal with those time parameters, and so don't feel too confined by those limitations. After the 2 presentations, the town hall will be opened for public comment. Members of the public may present their own suggestions for revision or comment on a suggestion presented by another member of the public. The ALSs may also have questions that they would like to pose to the presenters. This is an opportunity to engage in dialogue on any matter relating to the rules. Members of the public that participate today are invited to identify themselves and describe your role in the appeals process, but you are not required to identify yourself to attend or participate. The proceeding is scheduled to end at 11:30 today. I will note that the commission will not be making any decisions in this meeting, and that this town hall is supplemental but not a replacement for the notice and public hearing provisions for implementation of rules under the Administrative Procedures Act. The hearing today is being recorded and will be transcribed. And I would like to say two more things before we go into the presentations. On behalf of the commissioners, I want to say thank you to the presenters and the members of the public who are appearing here today to inform and educate. We appreciate the deep level of thought and the time that you devoted to preparing suggestions for the commission. I am truly looking forward to your presentations and having a lively discussion with the commissioners and you. Finally, I want to introduce the Zoom meeting facilitator, Ken Milborn from Merge Live. He will now describe some of the technical items for the town hall and will be moderating the Q&A for the public comment portion.
Thank you, Commissioner Patrick. Real quick, I think a lot of people are familiar with Zoom, but I just want to make sure that everyone is kind of on the same page here. One of the things, since we have a lot of people, one of the things that helps quite a bit, and it's your choice, would be to select gallery view. That way you'll see everybody on your screen. Gallery view kind of gives you that that Brady Bunch view, or as some people would say, the Hollywood Squares view. I tend to like that one the most, but that one's your choice. The other point to mention is we have two types of participants in this meeting today. We have video participants and phone participants. And I just want to briefly describe how you can interact in this meeting. So for the video participants, if your camera is up and available, when the time is appropriate, we've decided the protocol will be to raise your hand if you have a question or a comment. And Julie will manage you know, how that's selected. If you are in the video portion of this and for some reason your camera is not working, you can also use the raise your hand feature in Zoom, and that can be found at the bottom of your screen after clicking participants. Now, for the phone participants, obviously you don't have a video screen. So the way you interact is by pressing *9 on your keypad. And again, this will be at the appropriate time. When you press *9 on your keypad, that will raise a virtual hand, and we'll see that, and that'll put you into the queue. And again, we will take the questions when they come in. We will call on you when you're on the phone.
Ken,
yes.
I'm just going to interrupt real quick because I had somebody from the UIA send me a message seeking a link to the YouTube video, and I would like Verna to pipe up and set forth the address of our website and where it can be found.
We'll do that, Julie.
Thank you, Verna.
Yes, and I think that's another important point to mention is that this meeting is now live on YouTube. Okay, again, for the phone callers, just to wrap up that point, *9 will raise your hand, and we will call on you by stating the last 4 digits of your phone number. And I think that is it. Now, any questions from anyone from a technical perspective? I don't want to go off into the weeds too much on this. I think, like I said, everybody is using Zoom, and I know that we've been able to kind of work through some of the details. So if there are no questions, I'll turn it back to you, Commissioner Patrick.
Thank you. And Verna, can you recite the link to the YouTube and our website address?
Just 1 second. Give me 1 minute.
Sure.
Okay. The link is https and then it's www.youtube.com/channel/U, C as in cat, Y, K, D as in dog, 7, K, S as in Sam, N as in Nancy, space, H, W, P as in Paul, F as in Frank, 6, D as in dog, Y, 7, hyphen, K, O, N, A as in alphabet.
Verna, the link is on our website, right?
Yeah,
What's our website address?
Oh, okay, hold on. Just 1 minute, Julie. Sorry, I should have had all this ready. I just didn't.
That's
So-
okay.
It's michigan.gov/UIAC.
Thank you, Bill.
And then if you scroll down to Commission News, the link is there. All right, then with that, our first presenter is Rachel Cole, and she has given us the names of her 2 students, but I did not want to try and attempt the pronunciation of those names. So I will have her do those introductions as well. Thank you so much for being with us, Rachel.
Thank you so much, Commissioner Petrick, and the fellow commissioners and everyone else that's here on behalf of the Michigan Administrative Hearing System for Unemployment. We really appreciate this opportunity. My name is Rachel Cole. I am the director of the Workers' Rights Clinic at the University of Michigan Law School. With me today, I've brought 2 students that I will also do my best to pronounce their names, Hoost Wyndham and Dylan Rosine. They will be presenting primarily for what we submitted earlier last year for our submissions to the commission. But a little bit about our organization. We are a student-run clinic. We primarily help unemployed, jobless workers looking to proceed through this semi-complicated system. We represent between 200 to 300 people a year, and we have some deep insight into the challenges that claimants face in the unemployment system and while they are dealing with unemployment. And with that, I'm going to turn it over to Hoos.
Thank you very much, Rachel, and thank you, commissioners, for holding this town hall. I wanted to start by emphasizing that Michigan's unemployment adjudication process is very difficult to navigate for the average claimant. It is often their first encounter with any kind of quasi-judicial or administrative proceeding. They don't have any real knowledge of the applicable law, and they don't have the time or resources to acquire that knowledge in time for a hearing. And they don't have access to legal advice or really know where to find legal advice about the issues that they're facing. And at the same time, the stakes they face are very high. A negative decision could mean a loss of access to basic necessities. It could risk eviction. And in fraud cases, it could mean potentially thousands of dollars in penalties that they cannot afford. So we are proposing several rules that are designed to make this system more accessible to the people it was designed to benefit, namely those who become unemployed through no fault of their own. The first of those is that we think the Commission should provide counsel to indigent claimants. There is already an existing advocacy list that could be used for that program. And doing this would dramatically improve access to the system for claimants. It would allow their claims to be heard on the merits in the first hearing without getting lost in the weeds of procedural mistakes. It would also greatly improve the efficiency of our adjudications because there would be far fewer late appeals, and all the issues could be heard on their merits in the first hearing. Our second proposal is closely related. We believe that the Commission should permit written argument whenever a claimant is represented. That again improves efficiency of adjudication, especially where a case is complex. And it can be achieved with a very minor change to the existing rule the Commission has on written arguments. Finally, I wanted to address an inconsistency in the current rules that we believe the Commission can use this opportunity to remedy. Recently, the Michigan legislature amended the MES statute to require the agency to reopen any case upon a showing of good cause. So previously, the agency was simply permitted to reopen when good cause was shown. It is now required to do so. The Commission's rules, though, are now incongruous with that new standard because it still has the discretionary standard for reopening cases. So the standards that the legislature has rejected for the agency. We propose that where good cause is shown, the Commission too should be required to reopen an old decision. And with that, I will turn it over to Dylan.
Thanks, Hoos, and thank you to the commissioners for dedicating your mornings to consider these proposals. We appreciate so much the time that you're spending to think through a way to make our administrative hearing system better. I'm going to speak on a couple more of our proposals and then also spend a moment discussing some of the other proposals that you have before you this morning. The first proposal that the Workers' Rights Clinic proposed here that I would like to discuss is an effort to better self-regulate the Commission's jurisprudence by allowing the Commission to hold an en banc panel, either by a vote of the majority of the commissioners or in cases where there might be a first impression, whenever the chair designates such a case for an en banc review. The second proposal has to do with de novo reviews of factual findings before the Commission. So currently the Commission does have the ability to hold a new hearing to find new facts. And the Workers' Rights Clinic believes that where the Commission is going to find new facts, there should in fact be a new hearing before the Commission. And if there is not a hearing, as sometimes happens currently, then the Commission should provide a reason why it is not holding a hearing. And then the third and final proposal that we have submitted is that the Commission should consider publishing decisions and data on its cases. For instance, highlighting the number of reversals or affirmations of cases that advocates can filter by issue area or by winning party to allow for more fulsome advocacy across the state and a better understanding of the appeals that are before the Commission. And now I'd like to turn to look at some of the other proposals that you have before you from a few of the other organizations that I believe some are here today. The Workers' Rights Clinic looked at these proposals, and as to the Michigan Manufacturers Association's proposals, the MMA, first of all, we believe that this town hall is not the appropriate forum to consider the proposals that MMA has presented to you. They actually fall outside of the rules that the Commission was considering today. They're more rules and not Commission rules. But looking at the actual substance of those proposals, we believe that the first proposal to allow an extension before conducting a hearing would actually harm claimants who have to wait for benefits. And so any extension to that notice period would delay the time in which they could, before they would receive their benefits. And then their second proposal to change the rule to allow an in-person hearing, we believe is unnecessary because the Commission already has within its discretion under rules 420 sub 5 and 422 sub 1A to grant those in-person hearings. And so it would be unnecessary. And in addition to that, would be an undue burden on claimants who would have to navigate to the limited in-person hearing locations across the state. And for those reasons, we don't support either of the proposals that MMA has submitted to you. For the Farm Workers Legal Services, the Workers' Rights Clinic supports in full all of their recommendations. And as to the proposal from Attorney Seidel, which would allow written arguments whenever a party wants to submit one to the Commission, we do not support this proposal. We believe that requiring the Commission to take up a written argument whenever a party wants to submit it would tip the scales towards employers who can actually afford representation to craft those legal arguments, in addition to the fact that employers have better access to information when crafting those written arguments. And so for those reasons, we do not support Attorney Seidel's proposals. And I believe that concludes our remarks. Rachel, I'm going to just kick it back over to you, and then of course welcome any questions from the commissioners.
With that, I will turn it over to the commissioners for questions.
Okay, thank you very much for that very helpful presentation. And at this point, I see that Les Ocharski, Commissioner Ocharski, take it away with your question, please.
With regard to representation, when the advocacy program was originally established, they provided for appeals to the Board of Review. And as the program progressed, for some reason, they eliminated that portion. But originally, when the program was established, they provided appeal to the Board of Review. The program, for some reason, has sort of fallen into disrepair in that originally the representation was much higher. And what happened was I don't know for what reason the agency did that, but they cut back the reimbursement. And so what happened was the advocacy program started to atrophy. And we really don't have any power to, direct towards the agency. But that's an issue, I think, for the administration to reinstitute the reimbursement and to allow appeals to the commission, because originally they did allow representation on that.
Just to follow on Commissioner Ocharski's comments, I will note that on the website, our UIAC website, we do have a list of representatives. And I concur in the student statement that this process is incredibly difficult for claimants and employers to navigate. And so that list of representatives includes representatives that represent both claimants and employers. And one thought that might be helpful, although it may come too late in the process, is to, in fact, include a paper copy of that list when the notice of receipt of appeals goes out. But oftentimes, I fear that that may be too late in the process as well. But I would welcome any other suggestions on how. Obviously, we're constrained by budgeting issues and we don't have the ability to expand the advocacy programs. And so, various ways to get parties assistance and information on how to navigate this process would be something that we're always interested in. So if you have any comments on that.
Yes, well, I know that as far as the Workers' Rights Clinic goes, we represent people for free already. And so that is something that if the commission had the ability to appoint free legal counsel for claimants, if the Workers' Rights Clinic could be one of the parties that gets appointed to this indigent claimant. And there also might be additional other resources out there that do represent people for free. I know Sugar Law Center tends to do things as well for free for certain claimants, depending on their income threshold. And as well, potentially, there might even be some opportunities for us to grow into legal services as well, because I know that there have been some legal services, throughout the state that have started doing unemployment cases due to the recent surge caused by the pandemic. And so I think there are ways that this can happen regardless of whether or not the commission and the agency can find something to expand the advocacy program. I do agree that the advocacy program needs to be tweaked and improved. And hopefully that's something that this administration with the UIA is willing to look into and improve going from there. But regardless of whether or not it can, this type of rule would be nice to see, so that claimants that, especially when they have a complicated issue before the commission, have access to representation.
I do want to question further on the issue about the written argument and your position with respect to the other options that were presented. The written argument issue was the one that we received the most comment and interest on, and it is something that we are definitely looking at and considering. And I'm very pleased that, in fact, there are so many parties that are interested in presenting written argument, and there are so many incredibly complex cases and issues that that we are facing these days in light of the new programs and some of the changes in the act and the new amendments. One of the concerns that I would have in terms of a one-way ratchet system that you propose is that it might be subject to an equal protection claim. And I'm wondering if you have given any thought to that. And the other question that I would ask would be that if we were to expand the rules, I mean, because right now we are very much confined about how and when we can consider written argument. And I'm wondering if you would be, as an alternative, if you would be interested in expanding it in instances when no parties are represented or parties on either side, one or the other.
Hoos, do you want to add anything or do you want me to go ahead and answer?
Julie?
Yes, Commissioner Wojciechowski.
Yeah, I'd like to comment on the written argument
Sure.
proposition. The rule was originally introduced in the late 70s, and it was introduced by the UAW. And what their position was at that time was that employers are more often represented than claimants, and so to allow written argument would disadvantage the claimants. But I think that there's another issue here, and that issue is that English is very difficult to write. That's a quote from Ernest Hemingway. And we have a problem now where we receive more late appeals from both employers and claimants because it seems like the comprehension level has slipped with the general public. And to word the providing of written argument may confuse the issue for both employers and claimants. And like I say, it would have many unintended consequences. And so I think the rule has worked pretty well over the last 30 some years. And to insert into the notice that issue, I think it would be very difficult for the general public and employers.
Thank you.
And I just have I'm sorry, Commissioner Petrick. Go ahead.
I was just going to have take it back to you, and I'm particularly interested in the equal protection issue on allowing claimants to provide written argument in a different set of circumstances than an employer.
Hoos, I see you have your mic unmuted, so I'll let you go first.
Yeah, I wanted to first comment about your proposal that parties could submit written argument when no party is represented.
Correct.
And our concern with that is that, as I emphasized at the beginning, claimants just don't have equal knowledge of the legal issues at play than employers. Employers go through these cases often. It's probably the first and only time for claimants who go through this proceeding. And so we are really worried that this will create an inequity because the employer will know the issues that are relevant and will have done this before and will gain some advantage by the ability to present their arguments in writing. Whereas the claimant, unless they're represented, is not going to gain very much, if anything at all, by presenting the argument in writing. So this is why we were not supportive of the proposal to permit both parties to submit regardless of counsel. Of course, the concern about counsel becomes less severe if we do refer people to counsel, as our other proposal suggests, because then the standard case would be both parties being represented.
Okay.
Rachel, I don't know if you want to comment on the equal protection claim.
So I haven't given enough thought on the equal protection claim to be able to have a well-articulated answer here. But I do think that exactly what Hoos just brought up regarding if there is an ability to level that playing field by appointing counsel to a claimant who is indigent for a complicated issue, not only does that help serve the claimant and the claimant's case for unemployment, but that also will alleviate any concerns for both sides that want to present a written argument on that complex issue.
Julie, I have a question. Julie?
Commissioner Runco, please.
Yeah, thank you. So I'm really not clear. I just took a look at, again, at your January communication where you discussed written argument. And are you suggesting that we change the rule? Because it doesn't really say that. Or are you suggesting that we just adopt a more, maybe a different standard from our perspective when we review requests for written argument? That's the first question. And I have a follow-up question, but what is, you suggesting a rule change then, or just the way we do business?
Suggesting a rule change that there is an opportunity to present written argument beyond what is currently written in the rules.
Okay, and then that being the case, have you given thought to the deadlines in terms of the amount of time a party would have to submit the written argument and then a responsive pleading? Keep in mind that we are under pretty strict federal Department of Labor standards to dispose of cases, I think within 40 days. We have a case age that we should be under 40 days. And I think, and Julie can correct me if I'm wrong, but I believe that 90 or 95% of our cases are supposed to be resolved or disposed of within 45 days. So, with those kinds of constraints, what would you suggest in terms of the opportunity to submit the argument and then a response, excuse me?
I think that the current rules that are already in place with the timeline, I believe that there's 2 weeks from the receipt of the notice of receipt of appeal is the application period for the written argument. And then there's a 14-day response time for a reply that's already in the rules would be appropriate as far as the rules go.
Yeah, and see, I don't know, I don't have the historical background, maybe Les does, but that backs us over deadlines pretty much from the start. So
Let it go.
What about something, I mean, could you live with, if you were writing this rule, could you live with the time periods set forth in MCR 2116 for motion practice? Basically a motion's filed, they give 7 days notice, a responsive pleading has to be filed within 4 days. That might be a little bit difficult, but how would that strike you?
My only concern with that
7
is
days
that
and 4 days response.
my only concern with that timeline is the fact that it's hard to receive the mail in that amount of time. So by the time we actually would receive, the employer's argument or vice versa, the employer receiving our argument, it makes it significantly more difficult for us to be able to write that response within a couple of days.
Well, could you do it, for example, if it was community, and I think that rule talks about personal service, et cetera, versus mail service. But if you were to receive it, could you turn around in 4 days? As you know, the old trick is when you practice, you serve someone on a Friday if you're in Wayne County, because the motion calls the next Friday, and then to work the weekend, and because they've got to have their response in by Tuesday. But could you live within that circumstance, those time parameters, if you had it on a timely basis, if you wanted to write a response?
I mean, I think that it is a difficult, truncated time frame that would be hard, but I think that it is doable. I think that the current timeframes are more acceptable for both employers and claimants, because claimants are likely going to need to find that counsel if they didn't already have it to begin with, and then employers likewise either are going to have to determine whether or not they want to hire counsel for that and be able to get all the paperwork to their lawyer. So I think that the timelines already proposed are preferable. If the commission wants to consider lessening them in order to help its own docket, which I completely understand the pressures that those timelines put on the commission create, I think that's something that would be interesting for notice and comment.
Lastly, let me say that one last thing I just wanted to say that I'd be remiss if I didn't say, I wish I would have had the opportunity to take the clinic when I was there 40 years ago. I should say, I hate to say 40 years ago, but 40 years ago at the law school. So you're doing a good job. Thank you.
Thank you very much.
Are there any other commissioners that have questions on the U of M presentation? Commissioner Young. And you need to take yourself
Looking
off
at all your
mute.
faces, everybody's like, oh man, so sorry to be here. Man, this is good stuff. We should be smiling. We're doing unemployment nerd stuff, wonk stuff. This is a good deal. And we realize in a lot of things here that we don't want to come or present ourselves as being naysayers right away. I know that, we're looking at some things historically, and I think that's one of the perspectives we bring. At one point, back when in the old Board of Review, there was actually a 20-day period to request oral hearing. And then there's another 20 days after that to submit written argument, right? That you had that, those opportunities, and if both sides were represented. I mean, but the problem was at that period of time as well, our average case aging was probably, closer to a year. And at some point, we weren't as worried about the Fed as we are now. And the federal government has obviously said, hey, this is administrative law and you need to figure it out. And you can have so many of these cases that go late. They allow us, we have a category for cases up to a year, but we have to be judicious in which cases fall in that route. And so we are literally in this process of trying to balance these things the same way you folks are. And as much as, we talk about, well, in cases where for a claimant to find representation, we've also seen the cases where sometimes a case, it's probably better that a claimant didn't waste time, or for that matter, even an employer, it doesn't matter, either side didn't waste time, energy, or effort on getting a counsel and incurring that expense, because we've seen those briefs that come in where nothing has really been added other than expense, and the case itself was pretty straightforward. So we know there's that balance, and we're really just trying to find that and how we can do it and still meet our timelines. The two things that I had based on the letter, and again, these are not, I really want to be careful that in any way that this isn't a gotcha situation or any type of attack, because you raise interesting questions. That's what we're here for, to try to figure out where we're going to go forward. But on one of them, I just would go forward on the question about the reopening, and only because the statement. So this isn't wait a minute, but you're talking about the 30-day protest period, and certainly we'll go back and look at the act and that language change, and if we can bring our rule into conformity, I mean, of course, why wouldn't we? It's a great time to do it. This is great. But what I do want to point out, as it said in the letter there on that end of that paragraph 1. It said that under section 34, the commission may, for good cause, reopen review a prior decision of at that time the MCAC, and issue a new decision after the 30-day appeal period expired. And then you continue on, it says, under its current interpretation, the commission only grants a reopening if there's a demonstrated abuse of discretion by the earlier adjudicator. And I think I wanted to kind of clarify, again, I'm not going to speak for all the commissioners, but if anybody disagreed with that, I would think that they could raise their hand. But I would say under the current interpretation, that if it's beyond 30 days, that we do not have the higher standard of abuse of discretion. I mean, good cause is actually abuse of discretion is a pretty high standard to meet. Good cause is more of a factual statement, is it or isn't it? And I think that anytime we get a reopening request, our consideration is currently good cause, right? If it's over 30 days, and you'll see it all the time, when we're discussing among ourselves, or even in the decisions, if it's a reopening, we say good cause was not established to grant reopening. We use the abuse of discretion standard on the rehearings, right? And we said there wasn't any. In fact, if you're coming back on one of our own, we just deny because of mere disagreement. If it's our own, we don't even have to apply that standard if it's a rehearing request to ourselves. But if we're looking at a reopening denial from an ALJ, we're applying the good cause. And if we're looking at a reopening to us from one of our decisions, we are applying the good cause. So I'm saying so it concerns me just a little bit that you may believe that we're applying the different standard. That is the statutory standard, the real standard of the good cause. That is the one that I apply. I know the commissioners I work with apply. I just wanted to clarify that. Does anybody disagree with what I said on the commission? Look at me, put them in the hot seat. Yeah, they're going to raise their hand now, right? Fat chance. Les does. Can you just turn Les's camera off, please? Oh, no. So go ahead, Les.
No, I very much agree with you, but I just wanted to give a little history. The act was passed in 1933, and from 1933 until the 70s, the appeal period was 15 days. We had the big recession in the 70s, and the UAW came in and said the 15-day period was too short. There were late appeals, and they increased it to 20 days. Within a year, it was raised to 30 days. And it seems that the more time you give, procrastination seems to set in. And now we get more late appeals or lack of prosecutions than we did when we had the 15-day appeal period. So I'm just giving a little bit of history. Because of Java, we're under a time constraint. And in the past, we were sued by the feds this was not the commission, of course, it was the old Board of Review, when we failed to meet the 45-day timeliness standards. And we were under court supervision for over a year. And orders were issued as to how we were supposed to review cases, and we had to report on a monthly basis to the court how we were working towards reducing our 10,000 case backlog. So just a little bit of history.
On the note of late appeals, it's true, there are some people that you can give instructions and hand-holding, and there still will be late appeals no matter what happens. I do think that, in terms of being able to assemble, get help, get the information, 30 days is a very appropriate appeal period. And additionally, I will also note that since we have implemented electronic filing of appeals, that the number of late appeals has actually reduced quite a bit, because we don't have to worry. And particularly this year, when there were so many delays in the postal service, I think so many people did. And the ALJs actually have done an excellent job at more of notifying people of that electronic process. So I'm very grateful for the people over at Moore that did that. Although it does raise issues also of unequal access to justice for people who don't have the technological means. And that's something that we are also always sort of considering and thinking about in terms of making changes to rules and procedures at the commission. So I don't see any other commission hands. There's.
I did have the second part of my thing here. And so Dylan, I listened to your presentation with interest, and you talked about the de novo review of factual findings, and that, of course, coincides with paragraph 8 of the letter that was sent in January. And I'm a little confused on this because it's the idea that you said that the de novo review of factual findings, if we do this, we should hold a new hearing, which I'm thinking if we're talking about, if you're saying about admitting additional evidence, maybe. But then I'm reading the paragraph, and it says here that this is for those who don't have the benefit of the letter. I think it's just a paragraph. It says the act does not explicitly provide the commission with authority to conduct a de novo review of the ALJ factual findings. And then there's a footnote to section 34. But it says however, the commission appears to have taken such license anyway and issues de novo factual findings on appeal without the benefit of a new hearing. This decision makes for questionable jurisprudence. De novo review of the facts by the commission should only be allowed after the commission conducts an independent evidentiary hearing. So I guess the question is, I'm trying to, two things, I guess. One is understand the context for that. I mean, an example of where you've seen this happen or what you're objecting to. And then the question, of course, then would be what standard review would we use? If there's, as you say, that, it doesn't explicitly provide for de novo, but of course it doesn't explicitly provide for anything else either. I mean, and of course, case law has said it's de novo review. So as I'm reading this and the request is, if you can give me some background on that, I'd appreciate that.
Sure. So I think if I can take the second part of your question first. So you're right to point out that section of the Act which allows the commission to order additional evidence if it conducts a hearing. I think that's Rule 422(1)A. And the section that we're actually looking at amending or proposing an amendment here is 419, which would include an additional subsection between rules 2 and 3. And so this gets at your question around the standard of review, I think. And it would be that the commission would conduct the de novo review only after conducting that independent evidentiary hearing. I think Rachel can probably provide more background as to the first part of your question. So I'm going to see, Rachel, if you can provide some more context on that. Or
Yeah, I think that this concern generally is just like the commission's the last stop where we're still in this administrative world, right? Where we still have the claimants can still present the case that they need to present, employers can still present the case that they need to present before it then goes over to the judicial branch if it's going to be appealed beyond there. And so having because the commission does have the ability to conduct a new hearing, I personally have never seen the commission use that discretion. And I haven't seen the commission use the discretion to grant oral argument either. And I think that would be something that is helpful for these cases, especially the ones where there are these factual concerns and or legal concerns that might require additional detail provided by either party. And also at times we have seen that while the ALJs are doing a wonderful job below, there are times where, important facts did not get brought up on the record. And so having that opportunity to be done at the commission or to have it remanded back to the ALJ to conduct that factual finding, which is something that I have seen the commission do, I think would be an important last step before this case becomes, kind of the final record package that it is before it moves over to the judicial branch.
So you don't have a problem then? I mean, I guess what I'm saying when you talk about the standard review, and I'm just trying to clarify this is more focused at additional evidence that the ALJ did not consider because it wasn't in the record? Or is this the idea that the commission is substituting their opinion for that of the ALJ on the same facts? And they're saying that, the ALJ looked at the facts this way and we say, maybe credibility, and the commission says, no, we find this to be otherwise on the record. So I'm saying there's two. One is you want additional evidence that's not in the record, and is the commission utilizing that without properly admitting it under the auspices of being de novo, or are you looking at the record that's there in the commission just saying substituting itself for that of the ALJ's decision?
It's probably a mix, but I'm leaning towards the former of the two scenarios that you presented, of trying to get that additional evidence on the record. So I'm sure that there might be things under both of those categories that might be questionable. But I think that the former is really where our concerns lie.
Okay.
I think Hoos, did you have something you wanted to quickly add? I saw your hand. I'm sorry if I jumped on over you.
I know that was on a previous point. I just wanted to suggest with respect to the written arguments and the concerns about the deadline for moving cases through the system, as well as the possible equal protection concern. An alternative would be to add a subsection E to the current rule that lists the circumstances among which a written argument is permitted, and just say that at the commission's discretion, written argument could be requested, even if only one party is represented or no party is represented. That way, we prevent the concern with equal protection by writing in inequity into the rule. But we also permit, in some cases where a claimant is represented and has a complicated argument to make, the commission to permit that claimant to submit a written argument in those rare circumstances.
Thank you. Seeing no other questions or comments at this point, and that we are running a little bit over, but not too badly, I would move to go ahead with Mr. Slabod's presentation.
Thanks. So I was already nervous about presenting to a commission via Zoom, and then yesterday, two lawyer videos went viral. One showed a lawyer stuck in a cat mode as an animated cat. Another one showed another lawyer presenting to Congress upside down. So if Ken could just confirm that I'm not a cat and I'm right side up before I begin.
We're not a cat.
I appreciate that. All right, thank you. So my name is Dorian Slabod. I'm an attorney with Farm Worker Legal Services. Thank you to Commissioner Petrick and to all of you commissioners for having me here today, for the invitation a year ago to talk about this issue, and for the time investment to look at the rules themselves and try to make them better. I think that's admirable, and it shows that you're trying to do well for workers and employers here in Michigan. So I work for Farm Worker Legal Services. We're a nonprofit legal team, part of the Michigan Advocacy Program that serves most of Southern Ohio, or Michigan, sorry, a recent transplant a couple years ago from Ohio, with about 17 offices here in Michigan, and Pharmacal Legal Services serves the whole state. So we see workers traveling throughout Michigan, and we help them with their legal problems as it relates to their employment, which includes when they're ultimately denied unemployment benefits, if that should happen. So, so for the record here and for my presentation, I just want to highlight what we put in our note a year ago and then dive in deeper into one, because I think it merits a little more discussion. So in our comment a year ago, we made about 5 suggestions. And again, for all of my suggestions, all of you know the rules better than me. And really what we hope to provide is some insight into the real lives of workers. I think a lot of this is left out of the hearing. A lot of it happens before the hearing, or a lot of it happens because there never is a hearing, because people are either afraid or unable to access the system. So just briefly, the 5 suggestions that we made. Number 1 was greater latitude for late filing for relocating workers. 2 was the publication of notices and guidance materials in languages other than English. 3 was the utilization of certified interpreters and a rule that clearly outlines the interpreter request process. 4 is low cost or waived cost access to hearing transcripts. And 5 is easier access to the case file documents for lawyers who file their appearance. And I'd like to talk a little bit more about our first comment, which is providing greater latitude for late filing for relocating workers. So as you know in the rules, you can reopen a case after 30 days for good cause. And as Commissioner Young stated earlier, those good cause reasons are, is it or isn't it? You know, it's really, there are a few very specific examples, and it does allow for other examples. But I believe that the examples there can create some confusion when you talk about relocating workers. So I represent farm workers. They follow the seasons. They work in Michigan for the majority of summer and fall, and then potentially travel out of state or other parts of the state to find other employment. I had a client specifically who was unemployed, was employed in Michigan, became unemployed in Michigan, traveled to North Carolina to find work there, received a notice sent to a proper address in North Carolina saying that he was ineligible for benefits, and then didn't realize until he was in Texas that he was ineligible for benefits. And while that was at a lower level than the commission, the same sort of 30-day guideline applies as well as good cause. And so the rules themselves, right? The rules themselves talk about a reason for good cause can be through untimely delivery of a protest, or a failure to receive a reasonable and timely notice, or a legitimate inability to act sooner. And I think these rules create issues for 3 reasons. One is that the vast majority of unemployed workers who seek to maneuver the system are unrepresented. The stat I put in my comment was 75%. I'd be surprised if it wasn't even higher than that are trying to maneuver the system without the assistance of legal counsel. 2, you can come to a conclusion based off of just the brief example that I had, where there isn't good cause. I think it's fair to say that if someone receives a notice to a proper address and they ultimately got it, you could say that it's their duty to make sure that they open that, and they don't have a good reason to reopen a case. I think that is a fair assessment. I want to jump into that more. And then 3 is that it pushes the burden of proof on to an unemployed person to produce something that, in this situation that I'm describing, and describes a lot of people who are trying to deal with the ramifications of unemployment, to create burden of proof that that doesn't exist in the rule itself, right? I mean, they received the mailing on time. So, as you know, unemployed workers are dealing with a very stressful situation. Farm workers especially, we deal a lot of times with people who are simultaneously terminated and evicted. And while they maneuver the system, they are trying to gain their bearings. They are trying to have a proper address. They are trying to have access to the internet. They are trying to to do a lot of things to make ends meet and just have basic security. And you all know all that. But the practical implication of this is that it becomes very difficult to maneuver the legal system within a 30-day deadline. And so the rules themselves, I think, create problems because if someone is unrepresented and they look at the rules themselves, they're going to read those rules and they're going to say, this doesn't apply to me. I got the notice, but it went to the wrong address. And they're not going to give themselves the opportunity to maneuver the system. And again, we're talking about people who are otherwise eligible for benefits. And the Michigan Employment Security Act is an ameliorative act. It is supposed to help people. And the fallout from unemployment can ricochet for months or years down the line. The chair doesn't really fall for some people until much longer after the actual unemployment occurs. And so the gap in the access to justice, as Commissioner Petrick, you mentioned, can happen not just in the immediate 30 days. It can happen just not at the ALJ portion of the adjudicative process. It can happen down the line, and we've seen that happen down the line. Especially, benefits can be denied or withdrawn much later, even after they are initially approved. So the fallout happens in unexpected ways. And so what are we talking about here? We're talking about people who are trying to relocate and then receive a notice that they need to appeal. And the burden of proof for what they're supposed to show just doesn't exist, right? And so the suggestion that we have is to be able to provide testimony that you didn't reside where you got the notice. And I think that's one sufficient example. I think it changes the conversation regarding proper postage, which isn't what we're talking about here. We're talking about people with housing insecurity and multiple addresses who are traveling to find stable footing. And so that's one example. I think there are other examples that could address this concern. But the problem here, just to summarize this, is that the rules are very specific, right? Good cause does say it's not limited to these examples, but these examples are pretty detailed and specific. And when you talk about people without a sufficient address or internet access, these rules do a disservice to them because it can be very easily determined that they received proper mailing and it was their duty to open it. And I would like to offer to the commission that there could be absolutely justifiable reasons that people receive mail to a proper address and fail to address the commission on time. And lastly, I just want to also commend the commission for updating the digest. I think that will provide clarity to workers and employers. And I don't need to preach to all of you the nuances of these rules and how having decisions can help illuminate those. And then I didn't say it, but all of the workers' rights clinics suggestions are great. Rachel is a gem in the Michigan legal community and in the unemployment insurance world. So anything she has to say, I'm sure is correct. And we had a chance to discuss both of our comments a year ago. And she gave me some insight on ours, which I appreciated. So thank you for your time. Happy to answer some questions.
Dorian, so thank you for your presentation. Your presentation actually brings up a question that I have had that's been sort of rumbling around in the back of my mind for some time, particularly in these times of the pandemic, which is how much access to technology to people that you represent have in terms of if we were to for example, people who are transient moving around a lot, but may have an email address, would it be helpful and preferable to be sending notices and decisions by email? Do they have access to this? I know that probably right now they can't go to a library if they have an email address and they don't have a computer. So if you could discuss that a little bit, and that would be helpful in framing some of the other things that are that we're thinking about.
Sure. So I think, if I could leave with one point is that the instability can happen unexpectedly. And I know I said that earlier, but even if someone does have access for a small amount of time or a large amount of time, it can't guarantee that they're always going to have access with a meaningful time to maneuver the system. And I say that because I think that applies more broadly to all workers. For farm workers who I represent, we're talking about people with limited English proficiency a lot of the time. And I know that was also in my comments, but the ability to maneuver MyWAM is just not possible. And the ability to maneuver the system through email, for a lot of these people, they'll need assistance from somebody. And then as far as internet access, that's also not guaranteed. Again, my clients are in rural areas, and you can't guarantee that they're going to have email access. So to your point, I think there are a lot of ways to help, but there's not going to be a panacea here. There's not a cure-all when you deal with people with the fallout of unemployment.
Okay. Any other commissioners have comments, questions at this point? Commissioner Young?
There we go. I'll tell you that, Dylan, I did like, again, a lot of stuff on here to go through. What caught my attention, a lot of it did, I mean, different questions, but the attorney access to MyWAM. I mean, I think I think if I could make this happen, in a way that's, no one's going to sit there and, it would work for everybody. I'd love to be able to do that. I think it's a great way to resolve, maybe more than any other way to resolve so many of these problems and difficulties that we're seeing for, all represented or parties. I mean, how much better would it be that the representative can get there? I noticed that you footnoted the fact that they're doing this in some level in Massachusetts. Do you have any, I guess the problem is, of course, for us to do it without the agency having already done it below, right? I mean, that's where this is going to have to get set up, that whole process for how would you, certify and give the direct access and all the computer stuff. But once it was done, obviously we'd use the same process they used. It's just a matter of having a rule at both levels. So that's not, to me, the holdup. But is there any experience at all? Do you have any anecdotal thing with regards to what's going on in Massachusetts? How long have they been doing it? Or is, I'm saying, because that's first I've heard of it. I think it'd be a really good reason to do it. And so I'd be all for it. But do you know anything more about it?
I can't speak to Massachusetts, but I can, if you don't mind, Commissioner, illuminate why this creates issues that you may have not considered. But as an attorney who represents people with unemployment insurance claims, it's not just a matter of access to documents. It's also an inability to coordinate efforts. So when I deal with clients with unemployment insurance matters, oftentimes they're doing as much work as me. They're talking to people at the agency. They're filing protests of their own because the MyWAM system does not allow for an attorney to file a protest, and so I send a fax, and that technology is obviously not the most expedient, and so that hasn't been included into the MyWAM system. So I would say that the ability to be myself in MyWAM, and to be a lawyer and actually file stuff with my name on it, I think serves the client, right? Because there are very corollary conversations going on with the agency, potentially at the ALJ or commission level, and so that's another benefit by having attorney access, is I would actually be able to put my name on something.
Have you talked to anybody at the agency about this, or is this the first time you kind of raised this, publicly, shall we say,
This is the only avenue where I've brought up this idea.
Okay. All right.
Other than commiserating to Rachel and other advocates.
All right. Well, I think it's got some legs. I think it's very attractive idea. And again, first time we've ever talked about it as well. So I'm sure give us enough time, we'll find a reason to not do it. Okay. But right now, though, it certainly is an interesting concept, and I think seem to solve a lot of issues. And I guess I would recommend that you guys, on your end, start working toward that through other venues as well. I mean, right now you've got some people on the call, maybe haven't been talking, and to say that this is something worth pursuing, and maybe try to get some of that anecdotal evidence from, because again, I'm going off your footnote here about the third party administrator, from Massachusetts, see what's going on. What did it take? Maybe they've got some language already. They can help be a guide. If you can, the more you can hand it to somebody ready-made, the quicker it would happen. So other commissioners may disagree with me. I'm not speaking for the commission on this, but when I read this the other day, I go, wow, that is that's a, I mean, in the parlance, common parlance, right? That's a game changer, right? I mean, I understand exactly what you said. And I love during what you said, the ability to be myself on my wham, you know, yeah, absolutely. I totally get that. That's a great, it'd be a great thing. So thank you.
Thank you, Commissioner. Thank you.
Commissioner Del Pino.
Sorry. Okay. And again, this is from my experience and my background. The third-party administrator, I wonder if that's currently being used in Michigan. And an example of that would be MHA. They're considered a third-party administrator and they do get access to my WAM. So I wonder if that's kind of what you mean, because I know that's what they do in Massachusetts as well. I did have the experience of working there for a little bit. So I know that that's usually what they mean by third-party administrator. So I'm not sure if, I mean, again, you said you didn't have experience with that. So I'm not sure if attorneys are able to use that tool as well, or if it's specifically kind of like a representative for or an agent for the employer or something like that.
Right. And again, you know, I can't speak to the specifics of Massachusetts system other than that I think it would be an easy fix to be able to sign in as an attorney, right? We all have P numbers. It'd be pretty clear to be able to provide my own authentication. And the agency already provides for notices of appearance. So it's not reinventing the wheel there either.
Right. And that, I don't know if we have anyone on this panel right now, but that might be an issue for advocates, right? Because not all advocates are attorneys with the P numbers and with that ethics that you kind of cited as well in your note. So that's something to think about as well.
And you know, and not to leave other advocates out of it, I think it's easier with attorneys because you have the rules of professional conduct and the obligation for factual statements and to be honest at all levels, right? So even on a MyWAM portal, which can have a ton of documents, it requires us to be more formal and limited in our scope.
Any other questions from the commissioners? Seeing none, I will close this portion of the town hall meeting and open up the meeting for public participation. And as I stated before, people can raise their hand with the icon and present their own comments, suggestions for rule revisions, or comment on a suggestion by another party, and that Mr. Ken Milburn will facilitate this. And thank you, Dorian Slaybod and Rachel Cole and her crew for your excellent presentations.
Thank you, Commissioner Petrick. Again, a reminder to anybody that's in the meeting, if you're logged in via computer or smartphone, you want to look for the raise hand feature. Typically, it's found by clicking participants at the bottom of the screen, and then you should see it off to the side. Those individuals that are joining by telephone, if you'd like to raise your hand, please press *9 on your keypad, and we will call on you on the order that we receive them. We do have a person with their hand raised that is logged in over a computer. The name goes by N. Makavikar. I'm sorry if I mispronounced that. Feel free to state your comment now.
Thank you. My name is Neil Magvicker. I'm with the Michigan Health and Hospital Association Unemployment Compensation Program. First of all, it's been an interesting discussion. I appreciate all the comments and recommendations by the various parties. My question is this: what is the commission thinking about with regard to changes? We haven't heard from the commission on what changes you are considering and what is stirring this. So just anxious to hear your comments. And maybe there was something posted on the internet or whatnot. I don't know, I may have missed that, but again, we haven't heard from the commission on what you're thinking about with regard to changes. Thank you.
Thank you, Mr. McVicker. I can't comment too much about the internal discussions at this point, other than to say that our objective is to make the process better for all, administratively for the parties. There's not one single rule that we have focused on. We are looking at the rule, the rules holistically at this point. So, and in terms of that, we are taking to heart all of the suggestions that have been made by the public participants here. So.
Yeah, and if I could just add, I think from our perspective, and I'm speaking, I think, on behalf of the attorneys that represent our clients, for the most part, the current rules do work. And those people that are, in that process on a regular basis, I think it's an effective process right now. But going to your comments, Commissioner, are there any general areas that you're looking at that you could at least tell us about? For instance, are you examining the notice period? Are you examining the process for requesting stays and things of that nature? So are there any broad categories where you are anticipating that you're going to set forth or propose some rule changes?
Neil, I see that you have your attorney cross-examination hat on today. I tried to deflect that question and you just kept going. So, I can't say any more than that. And I understand sort of the concern that you're speaking to. I too agree that the process works very well. And I don't anticipate any major overhauls of any of the processes at this point in time. We are open to suggestions from the parties as to what we can do to improve. My baby is to try and put in additional procedures in order to permit greater electronic access. I think that eases burdens on a lot of parties. Oh my goodness, the lights just went out in this office. Okay, that was my ghost face there. I didn't need a kitten emoji to come in today. So that's all I can say at this point in time, but that we are going to be proceeding along the lines with the APA as well. And so that there will be full disclosure when we do have a set of rules and an additional comment period too.
Okay, good. Just a final comment. I commend you for convening this town hall. Well done. And I appreciate all the people that did participate. It's good thought. Thank you.
Thank you, Neil. And Commissioner Young, I see your hand is up. And then I also saw Commissioner Ocharski, whoever wants to go first.
Yeah, Julie, I think what Neil is really asking, and I think why don't you just send him the email that's, double secret hidden agenda. I think that's what he wants. So if we can just do that and then he'll be okay. I tell you one thing that I'm looking at, Neil, and again, I think how this stuff comes about, I think that's the concern, right? I think just like anything else, we run into a one-off and then we wonder, why is it this way? Or something just seems a little bit weird. And, we start writing those little things down and kind of putting them together. And when we see enough of them, that gets us moving. And then it's probably been a while since we've done something like this as well, right? And Julie's pretty proactive about things. When she gets excited, it's kind of hard to, get her to back off. So she's like, oh, let's have a town hall. And then we're like, hey, let's not. And, and she's like, well, a year later, she look where we're at. So she's pretty persistent. But one of the things I'm looking at, I would say just personally, and when we talk about the rules regarding the transfer proceedings, and I think this is great that we have a cross section of practitioners here, because the thing that kind of always gets me, you can always tweak something, right? One way or the other. I don't want to go too crazy, but I've always hated this concept. And I mean, I understand it. I like I said, I think for the most part it works, but the idea of the 3 business days on the for a regular for it to be a regular request, right? And my point on that is that when you've got it really tends to work poorly for people who have hearings on Mondays or Tuesdays, or what could even be worse than having your hearing on a Tuesday after a holiday on a Monday, right? So if you got to do the 3 business days, that means your request has to be in what, that Wednesday before the holiday weekend. And if you only got the 10 days notice, I mean, you got the thing in the mail by the time you took a look at it. If you didn't get your transfer request in, now you've got to go through the process of, having it be one of the ones that we actually have to go ahead and approve. So the question is, without getting into the point where we tweak it too much, is there a thought on that? Does anybody in the practitioner component, is the 3-day thing okay? And I guess the only thing I'd see about doing it is, do we even consider maybe moving it to a two business day process? Because when this rule was initially written, or should we say rewritten for this with a transfer application, the process was primarily still in-person hearings. So the idea that, people getting a last minute, a stay back under the old rule 308, I mean, a stay request could happen, during the hearing, right? Someone could get get the hearing to go ahead, the ALJ to go ahead and pause the hearing, go off and send a fax, have their office send a fax to the old board of review or the commission, and the hearing would be stayed at that moment. I mean, that's how the rule was written. But the big thing was just having people, freeing up their time and traveling and everything else, and then having at the last minute hearing be stayed. So I think the idea that you have to have some advance notice is certainly helpful. But now, since we are doing things more, and I know some people wish things were in person, but right now we certainly are doing a majority of things by phone and probably will continue to do so. Do we need the 3 business days? And I'm not saying this is just me. I haven't spoken to any of the commissioners about this, but as I look at it, I think, again, it seems kind of crazy for the people at the Monday, Tuesday hearings or after a holiday. Would a 2 business day timeline serve the same purpose? Would anybody feel it'd be less advantageous? That's just my thought on it. And they all speak at once.
Commissioner Ocharski, did you have a comment?
Yeah, I think it was during the administration of Penny Millender, the late Penny Millender. Penny Millender and myself conducted a hearing on the rules and had all parties present, including, I believe, the Hospital Association, the UAW, the Michigan Manufacturers Association, and so on. And we had sent out the notices, and we had quite an interesting meeting. And after the meeting, all parties agreed, no changes to the rules. So the work that we had done and the proposals that we had made at that time were all rejected by the parties in interest. So we had proposed, 20 years ago, some changes to the rules, and they were all rejected by the parties. So this is just, 20 years? Time for another look.
Okay, are there any other questions at this point from any other members of the public?
Just one last call to anyone that is on the line here. If you're on a computer or smartphone, please press the raise hand feature. And if you're on a traditional telephone, please press *9 to raise your hand. Not seeing any other hands raised this time, Commissioner.
I will just make, since we have a little bit of extra time, there was a reference to the delay in the year ago request for information and comment and the now 1 year later town hall. And a couple of things that happened in between, not only the pandemic that happened, which caused some disruption in our proceedings, but going back to a little bit more in terms of the history of why we do need to make some rule revisions, which is that when the commission was in fact formed, we have a new name, it's now the UIAC, and all of the current rules reference the MCAC. So that is one reason why we do need to update our rules to make the applicable designations. But that also brings me back to when we were created, it was done as a part of reorganization between LAURA, the Licenses and Regulation Authority, under which the former MCAC was under, and that we got moved to LEO. And as a part of that, the new rule revision process had been started under a request for rulemaking that was initiated under LAURA. So because it was done under the authority of LAURA, in order to more appropriately recognize the new structure, we had to have a new RFR. And so that did not get put into place until November, or either somewhere in between September and November of this year. And that, I believe, is a public document for people who are interested in looking at that. So it is now more appropriately aligned with the new structure that is in place. And under the Open Meetings Act, excuse me, not under the Open Meetings Act, under the Administrative Procedures Act, a town hall meeting was recommended not to be convened until there was a new RFR in place. So that is part of the delay in getting to this town hall meeting at this point in time. So, with that long-winded explanation of that process, having no more comments from the public, I will close out the meeting at this point in time. And again, I will say thank you to everybody who participated and presented. You've gave us great comments and insights and some things to think about. And thank you for members of the public that have attended and listened. And with that, I think we can close the meeting. Thank you so much.
Thank you, everyone.